That's correct, Your Honor.
And you're objecting to this testimony as hearsay?
Yes, as the affidavit was written outside of court.
Okay.
Which may, of course, in our court statement being used to prove truth matter asserted, is of course hearsay. And while opposing counsel is right where evidence may be used for impeachment purposes to circumvent the hearsay rule, that is only if that impeachment is valid and proper. There has been no direct contradiction between what Ms. Duran has told us and what is written within this affidavit. She has explained that there were moments in time, such as this, where her son may not have understood that guns were dangerous. There is no direct contradiction, and thus the impeachment is improper.
And so if this, I'm just a little puzzled.
Yes.
If this objection works, then the affidavit stays out of evidence?
Yes, sir. The statements from the affidavit that have been read onto the record.
Your Honor, specifically the rule that we're referring to and arguing today is 613B, and that's...
Slow down.
Sorry.
All right, old man, listen slowly. 613.
Yes. And that specifically addresses the question of whether or not external evidence is being allowed to be used for impeachment. It requires that it
Let me read it.
Sorry.
Your response?
I stand by my argument.
Specifically, the 613D evidence is admissible only if the witness is given an opportunity to explain or deny the statement, and an adverse party is given the opportunity to examine the witnesses.
In light of that rule, Your Honor, this evidence would be admissible as Mr. Rand was able to explain away the inconsistency that plaintiff alleges.
Okay, well put. So the objection is overruled.
Yes, Your Honor.
Thank you.
Thank you. I'll take that back from you. Now, Mr. Rand, you're aware that your son had a fascination with guns.
Guns and the military, yes.
And when it started with the military, he originally just asked for figurines.
Correct.
And then he moved to asking for video games.
That is also correct.
Eventually, he got bored with these regular video games and asked for more violent versions.
I think he wanted to see what war really would be like, so before he decided to fully commit to maybe one day being in the military, he wanted to see what it would actually feel like.
And that's why when he was 10 years old, you let him play first-person shooter games.
After I approved every game that came into my house, I played all of them in full to make sure that they were not too gruesome for him.
The reason you actually played them before they came into your house is because you were worried.
About what? I mean, I always worry about my children.
The ratings on these video games were for a more mature audience than your son.
Yes, yes they were, and I wanted to prove and make sure. I believe that if a child expresses interest in something, you should let them see that interest. That way they don't go out of their way to find that thing on their own. If I can control it, I will.
And Mr. Rand, to be fair, you weren't the only one who noticed this obsession. You're aware of Danny Brooks, the babysitter?
I am?
And he also noticed that your son was obsessed with these video games.
Yes, yes he was. He did not like my son very much.
And he told you that your son wasn't only playing video games, he was playing other shooting games.
Yes, with Cindy.
You did nothing to stop that.
No.
Instead, actually, I want to talk about some of the other signs that you noticed. You received a notice from the school about some of the fights that Jesse had been in.
I did?
Objection hearsay in regards to the notice from the school.
Your Honor, we're not using this for the truth of the matter, we're using this for the knowledge of Hayden Duran in today's case, that she had knowledge that her son was sent home on all 3 of those occasions and that her son was in these fights.
Your Honor, this information would be used for the truth of the matter asserted. The only way she could have attained that knowledge was from the notice itself. It is inferred, and therefore it is still hearsay, based on the fact that we have to rely upon the hearsay statements within the notice of notification of student discipline.
Your Honor, we wouldn't have to have the witness speculate to this. She's aware that her son was sent home on these 3 days. She probably was the individual who had to pick her up on these 3 days, and she was aware for the reasons why.
Good, so we'll do this. We'll sustain the objection, however, counsel, if you would just reframe the line of questioning, it seems like you can get at the information about what the witness actually knew without stumbling across a out-of-court statement.
Yes, Your Honor. You're aware that Jesse was sent home on 3 separate occasions.
Yes.
You actually talked to Jesse about this.
I didn't find the behavior appropriate at all.
Jesse told you that he had been in fights,
That's correct.
and you found out that he had kicked another child,
Yes, I did. I was appalled.
punched another child,
Again, same thing.
and he even bit another child.
Yes.
Now, I want to talk about the next conversation you had with Danny Brooks, the babysitter. This was the day before the shooting.
Yes.
Now, he told you that your son knew that there was a gun in that house.
Yes, Danny did tell me that.
He specifically told you that your child was going to use that gun.
That Danny was going to use that gun?
I'm sorry, maybe my question was a little confusing. Danny told you that Jesse Duran wanted to use that weapon.
I believe he wanted to
Objection,
see the weapon.
speculation. In terms of Danny Brooks inferring what Jesse wanted or did not want.
And Danny is the babysitter.
That's correct, Your Honor.
And your response?
Your Honor, we're just using this information purely for the fact that Hayden Duran had knowledge that Jesse may or may not have this intent. It's not for the truth of whether or not Jesse actually wanted to use this gun or anything like that. It's only that Hayden Duran had knowledge and could have taken action.
And I apologize because I was making a note when the defending question and answer. Could you just kind of run through that again so that I can understand your objection?
I asked Mr. Rand whether or not Danny Brooks had specifically said that Jesse Duran wanted to use the weapon. I had told her that Jesse wanted to use the
So
weapon.
this is eliciting Danny Brooks' statement said to the witness.
Yes, but in this case, we are not using it for the truth of the matter, only that Hayden Duran
Got it.
knew.
And Your Honor, that's why I'm objecting to speculation. This is Danny Brooks going directly into the mindset, the desires of Jesse Duran, who he has no capacity to do so. It does not matter if this is being used for the truth of the matter or any other reason, being subsequent action or command, what have you. That does not apply to speculation evidence.
And can you explain how the effect on the listener is relevant to somebody's burden in this case?
Yes, the effect on the listener is relevant because we're charging Hayden Duran today with negligence. The fact that she had evidence that her son wanted to use that weapon that day, and again, didn't even tell Amy Park, is relevant in today's case.
So whether or not the babysitter believed X or Y, why doesn't that make it admissible?
Because again, Your Honor, the babysitter has no way of knowing for a fact
Alright,
that
so
Jesse Duran wanted that,
my
therefore it's
question-
inadmissible.
Right, so my question is whether or not the babysitter believed X or Y. If the witness heard this person say that, doesn't that make it relevant to her state of mind and to the plaintiff's verdict?
To the witness's own state of mind, I agree with that. So yes, it would be relevant in that context.
Okay, so the objection is overruled.
Now, Mr. Rand, you are aware from, you heard from Danny Brooks, that Jesse Duran wanted to use the Parks weapon.
I heard from Danny that, yes, that there were some concerning instances about the gun, and that's precisely why I spoke with him about it that night.
You heard him say that he wanted to see a gun,
Yes,
he wanted to hold a gun,
again, yes.
and then after having that conversation, he shrugged and walked away.
Yes, he did. I had spoken with him many, many times about how dangerous guns were, and he left.
I want to talk about the day of the incident. Now, you left Jesse Duran there.
Yes.
You left him home alone at the Parks.
Yes, I was very nervous about leaving him alone. I never left him alone before, but Andy was also leaving her daughter alone, so I thought I could do this same thing with my son.
You also were worried because there was a gun in the home.
I was worried, and because of that, I took Jesse aside and I spoke with him about how this was a huge responsibility for him to be home alone and that I expected his utmost behavior.
You took him aside because you were nervous about leaving your son home alone with a gun.
I was nervous about a lot of things that day. I was nervous about leaving home alone. I was in fact nervous about the gun, but I did my best to prevent anything.
You were so concerned that when you were at work, you texted Jesse, reminding him yet again.
Yes, I reminded him again, do not use a gun. Guns are dangerous, they can hurt people.
Yet you didn't warn the Parks.
I didn't really see the need to. I thought that the Parks, I trusted the Parks' safety in storing a firearm. I didn't think that he would have access to it.
And you left Jesse Duran home alone.
Yes, I did.
No further questions.
And redirect?
No redirect, Your Honor. I simply ask my minutes to be allowed to step down.
You're welcome.
At this time, Your Honor, The defense rests their case in chief, and if opposing counsel is fine, we are ready to move to closing statements immediately.
Yes, Your Honor, the plaintiff is ready.
Yeah, so just, so this is cool. We'll move right in, that's awesome. We'll take your full 9, you get your full 9, you get your full 9. We're all good to go. Don't worry about all loss, okay? I can talk to them, that's fine, let's not. We don't need to be rushed, you don't need to be rushed, you get your full 9 minutes, but I agree it's appropriate that we don't get a recess.
Okay.
Are Your Honors ready? Or would you like a minute?
Please, go.
May it please the court. Today's case really comes down to a story about foreseeability, about something that could have been predicted and that should have been prevented. But Your Honor, the plaintiff wants you to believe, the defense wants you to believe that it should have been predicted and prevented by Andy Park, when the only one who was in a real position to predict and prevent this shooting was Hayden Duran. And this is because of context, members of the jury. Hayden Duran has a troubled child. Jesse's getting into fights. Jesse's fantasizing about guns and drawing pictures. Jesse wants to know what war is like. Jesse is fascinated with firearms. Jesse only wants to play games that, according to Hayden Duran, involve shooting hundreds of people. That's the child that Hayden Duran drops off at the Parks home, where she knows there is a weapon. All of this information about her child is the backdrop to August 18th, when Hayden Duran walks Jesse over to the Parks home, finds out that the children are going to be unsupervised, and leaves Jesse there. You heard our psychologist say there is no perfect formula for a perfect parent. There are lots of things that Hayden Duran could have done. She could have asked Andy Park, how do you store this gun? Is it super safe? She could have asked Andy Park, do you know that my child knows about your gun? She could have warned Andy Park, my child wants to play with your gun. She could have decided that because she was uncomfortable, as she testified that she was, she could have decided maybe to be late for work, take her son to a daycare, figure out some other arrangements that don't involve leaving her violent child in a home with a weapon. That is why Andy Park's daughter is dead. That is why Sydney Park and Jesse Duran were able to play with the gun. Because Hayden Duran left Jesse at that house and left Andy Park clueless. The opposing counsel wants you to believe that Andy Park is really the one who's responsible for her daughter's death. But Andy Park did not have foreseeability the way that Hayden Duran did. The opposing counsel tried to cherry pick instances. You caught your daughter looking through a filing cabinet. Members of the jury, this was months before the shooting, completely isolated, and it had absolutely nothing to do with the gun. Sydney didn't say, I'm looking for the combination to the safe that I know is in your room. Sydney was looking for a video game. And the opposing counsel wants to hang their hats on the fact that Sydney asked Mrs. Park about the gun the day before. But Andy Park was hearing this question from the lips of a child who had never been in any trouble, who didn't have an inordinate amount of interest in weapons, who hadn't been getting into fights at school. Andy Park was absolutely reasonable in the actions that she took. Were they perfect? No. And I'm sure the opposing counsel is going to come up here and tell you that. But they were reasonable. While Hayden Duran's actions were not. You heard from our psychologist, Hayden Duran's management of her violent son was completely insufficient. You heard from Hayden Duran and every single one of the defense's witnesses that Hayden Duran knew. about Jesse's interest in violence, about Jesse's interest in guns. You heard from every single one of their witnesses that Hayden Durand was constantly reminding Jesse, guns are dangerous. Why was this? Why was she so constantly having to say this to an 11-year-old? Because her 11-year-old was not a normal 5th grader. Jesse Durand was capable of violence. And Hayden Durand knew that. And that is why Hayden Durand had to constantly remind Jesse that guns are dangerous. And that is why Hayden Durand left to work nervous. But she left to work. And she left the children alone. But for her actions, this would not have happened. And that is what the law requires that we prove as the plaintiff, Your Honor. The plaintiff has a burden. We have to prove to you that Hayden Durand had foreseeability. That Hayden Durand could have known that Jesse was going to commit a violent act. That Jesse was capable of committing a violent act. And Hayden Durand had that foreseeability. Hayden Durand was a neglectful parent because she allowed that potential to become reality on August 18th. That is why Hayden Durand is the one who could have predicted and prevented this, not Andy Park. And that is why we ask that you find Hayden Durand liable. Thank you.
I'm gonna text the tavern and let them know.
Sounds good, Your Honor.
He's just a juror.
Oh, cool. Yes, Your Honor.
You may text the tavern.
Let the record reflect I'm texting the tavern.
Today I have a sign at the door that said, "I am the captain of this ship. I have my wife's permission to face it." Great. Okay.
Can I proceed? Your Honor, opposing counsel, gentlemen of the jury, may it please the court. Sydney knew that the Parks owned a gun. She knew how to gain access to it. And as much as it pains me to say this,